An individual with a valid will is known as a testator. A person dying without a will is said to be intestate, and their property is divided among their heirs through a process called administration, according to the Intestate rules of the Probate Code. The Intestacy rules also apply to property left over when the deceased provided a valid will that failed to dispose of all the property. The Intestacy rules of the California Probate Code often refer to equal shares. This means the property is divided among all members of a class equally. If one member of the class is deceased, that share is divided among his or her children equally. As an example, if the decedent's property is to be divided among his children in equal shares, 50% goes to child 1 and 50% goes to child 2. If child 1 is deceased, this share passes to child 1's children. So in our example here, 25% goes to grandchild 1 and 25% goes to grandchild 2. Grandchild 3 receives nothing. This may appear harsh, but perhaps grandchild 3 will be provided for by her parent, child 2, who receives 50% of the testator's property under the equal sharing rules. Under the Intestacy rules of the California Probate Code, when the deceased is married, the surviving spouse gets all community property and quasi-community property. 50% is already owned by the surviving spouse under the community property rules. The remaining 50% goes to the surviving spouse under the Intestacy statute. The surviving spouse also receives a share of the separate property of the deceased spouse. The surviving spouse takes 100% of the separate property as well as 100% of the community property if the deceased spouse leaves no children, parents, siblings, or grandchildren. Where the deceased spouse leaves only one child or grandchildren from that child, the surviving spouse receives 50% of the separate property. The same is true if the decedent leaves no children but is survived by a parent or sibling. The share of separate property going to the surviving spouse is 50%. Where there are several children, or one child and grandchildren from another deceased child, the surviving spouse's share of separate property is reduced to 1/3. The remaining estate, not going to the surviving spouse, is shared equally at the same degree of kinship among the deceased's children. If there are no children, it goes to the surviving parents. If there are no parents, it goes to the siblings, the brothers and sisters of the deceased. If there are no siblings, it's shared among the cousins and other issue of the grandparents. If there are no issue of grandparents to take the estate, it goes to the children and grandchildren of a predeceased spouse. Perhaps the deceased was a widower and his departed wife had some remaining family. Where there are no remaining issue of a predeceased spouse, it goes to the surviving parents of a predeceased spouse. Finally, before the property is taken by the state, the administrator looks for children, grandchildren, or other issue of parents of a predeceased spouse. The administrator obviously looks far and wide for kin of the deceased, but doesn't want to pay out to a person that's already died. If the individual hasn't survived for 5 days, 120 hours, after the death of the deceased, that individual fails to qualify and does not take under the intestacy rules.